Dear learner, it is time to see that what are the principles and theories of extraterritorial applications, and the study of principles and theories of extraterritorial application of competition law needs a clarity in determining the extraterritorial and extraterritoriality, leading to an understanding or a better understanding between the extraterritorial application of competition law, conflict of laws, and internationalization of domestic law. Many a scholar opines that extraterritorial regulatory policies as quintessential of the antitrust law and competition regulatory authorities, while others defines extraterritorial application of competition law as universal jurisdictionalism to be applied to domestic law to conduct outside their territory. Notwithstanding these reservations about extraterritorial application of competition law, even the best definition in the literature of competition law jurisprudence fails to address the important issue related to extraterritorial application of competition law. But the relation between territory and jurisdiction triggered the extraterritorial application into number one, territorial principles, protective principles, universal jurisdiction principles, active personality principles, passive personality principles, and territorial effect doctrine. Dear learner and viewers, we will be examining and discussing the ambit and scope of the relative merits and demerits of these principles in the extraterritorial application of competition law. The first principle, protective principle, is a sort of principle which essentially apply to a country to exercise jurisdiction over crime committed outside its territory when the crime threatens country's national security. The scope of this principle in the arena of competition law is not clear. However, the national security is a broad concept, one that might relate to political economy of the particular country, and it encapsulates economic and political issues often having repercussions on economic security of the country, and thus the protective principles can apply to competition law. The second principle is universal jurisdiction principle, which enables a country to claim jurisdiction over persons whose alleged crime were committed outside the boundaries of that country, regardless of nationality, country of residence, or any other nexus with the prosecuting country. This principle is limited to certain crimes such as piracy, slavery, torture, war crime, genocide, and other crimes against humanity given under conventions against torture and other cruel, inhuman, or degrading treatment or punishment 1984 and Geneva Convention 1949. Thus, the universal jurisdiction principle should apply to a competition law on the basis of an overarching and encompassing kind of a convention is a is an analogical deduction and is a debatable issue. Dear learner and viewer, the third principle of transnational competition law or extraterritorial application of competition law is active personality theory, known as nationality principles, and which facilitate a country for criminal jurisdiction over the conduct of its nation's citizens for a crime committed abroad. The application of active personality principle in competition law entails two scenarios about the jurisdiction of a country over anti competitive business practices of its citizens abroad. The first scenario involves a foreign based company subsidiary of a national or a multinational corporation. For example, a Canadian subsidiary of United States MNC is accused of abuse of dominant position in Canada. One might argue that the US court should have jurisdiction in this case because the violation is conducted by the US company's subsidiary, and the nationality principle allows a state to regulate activities of its citizens abroad. To this end, we can refer to the International Court of Justice decision in the Barcelona Traction Light and Power Company case, wherein it was found that a company which the shareholder of our Belgium nationality, having been incorporated under the Canadian law and having its registered office in Toronto, is of Canadian nationality. Therefore, despite the close relationship with US parent company, a Canadian subsidiary is a Canadian corporation, and, and the active personality principle should be applied or not to be applied to the US to its exercise to competition law can be well thought of. A second scenario involves the regulation of anti-competitive conduct of citizen in a foreign country. For example, the CEOs of two US corporations are both Canadian citizens and they operate a price fixing cartel in US affecting only the US market, although the active personality principle allows a state to regulate activities of its citizen abroad. To enforce such regulation in foreign territory is normally controversial when a similar law and enforcement mechanism exist in the foreign country. Thus, the two Canadian CEOs violated the Canadian Competition Act 1985 and they are not harming the Canadian market, and the US law is available to punish their offenses. In this scenario, what we infer that the active personality principle should apply or should allow Canada to assert extraterritorial jurisdictions of its competition law is left to anybody's guess. The fourth theory of extraterritorial application of competition law is the passive personality theory, which envisages to the territorial principles and allows a country to claim jurisdiction over acts committed abroad against its own citizen by foreign citizen. This principle appeared in the 19th century in the criminal courts of some countries and triggered conflicts between states. This principle is primarily applied in criminal courts and triggered in counterterrorism law and convention. The passive personality principle can be extended for the enforcement of the competition law against anti-competitive business practices of the foreign person in a foreign territory that have adverse effect on country's economy and society and the market. In a situation where we find an American company abuses its dominant position into US market and cascade harm to Canadian company under the Canadian Competition Act is legitimized in the enforcement in the US. In other words, we can say since Canadian Competition Act 1985 does not contain explicit provision, therefore US competition law can regulate the abusive conduct under the passive personality principle of extraterritorial application of the competition law. The last theory happens to be the legal effect theory or legal effect doctrine, which is based on three things. The one is prescriptive, another is adjudicative, and the third is the enforcement jurisdiction over an act conducted abroad by way of implication of the famous case known as the Lotus case decided by Permanent Court of International Justice in 1927. It applied to the competition law and calls for drafting a unified approach to extraterritorial application of competition law. According to the effect doctrine, a country may enforce its competition law against an anti-competitive business practice that took place completely in abroad if the conduct has substantial degree of effect on its own territory. Thus, the Permanent Court of International Justice landmark decision in the Lotus case applied by an increasing number of countries in the arena of the competition law despite strong opposition from many other countries. However, what we see that this principle fortified under the Lotus case and the Permanent Court of International Justice, the entire issue of the theory and principles of the competition law. Now it's profitable, dear learner and viewer, to examine the doctrinal legacy of the Lotus case, which offers a recourse to the extraterritorial principle and extraterritorial application of competition law. Because the Permanent Court of International Justice has changed the entire international law approach to the application of national law to the violation in notable conflict between France and Turkey in Lotus case. Legally speaking, the PCIJ Permanent Court of International Justice judgment are not binding as it has been envisaged under Article 59 of the Statute of International Court of Justice 1945, which simply says that the decision of the court has no binding force except between the parties and in respect of that particular case of the Statutes of International Court of Justice. However, if these decisions are not binding precedent, but well, it serves as a subsidiary means for the determination of rule of law under Article 38 of the Statutes of International Court of Justice, which says that the court, whose function is to decide in accordance with the international law, such disputes are submitted to it, shall apply in international convention, whether general or particular, establishing rules expressly recognized by contesting states. And number two, international custom as evidence of general practice accepted by the law. Number three, the general principles of law recognized by the civilized nations. And number four, Article 59, subject to judicial decisions and the teaching of the most highly qualified publicist of various nations on the issue of international law and determinations of the rule of law. Having perused Article 59 and Article 38 of the Statutes of International Court of Justice and taking the gist out of it in the context of the Lotus case decided by the Permanent Court of International Justice, we can safely move to three broad generalizations. The first, that a state can apply its law extraterritorially unless constrained by international rule. This rules means extraterritorial application of a nation's public law is a natural right of the states, not a right that derives from the permission of an international treaty. So we have to pause and ponder that the extraterritorial application of the nation's public law is a matter of natural rights, not a matter of permission by any international treaty. Secondly, that the judgment made it clear distinction between prescriptive, adjudicative, and enforcement jurisdiction over any kind of a conduct which is being done at a foreign country or a foreign territory or abroad. Here, it is imperative for us to understand that what exactly means the prescriptive jurisdictions, adjudicative jurisdictions, and enforcement jurisdiction having more ramifications and repercussions on the very understanding of extraterritorial application of the competition law. By prescriptive jurisdiction, we simply refers to mean the power to prescribe rules gauging from the foreign conduct. By adjudicative jurisdiction, we mean is the power subject to the foreign parties to judicial process. And finally, the enforcement jurisdiction is the jurisdiction which enforces a law in abroad. Thus, according to Permanent Court of International Justice, in Lotus case, the states are relatively free to make laws that regulate foreign conduct because prescriptive jurisdiction is conducted within country's territory. And the third notable point on the extraterritorial application of competition law made in the Lotus case to the effect of foreign conduct on the country whose laws were violated. This rule can be regarded as a limit by the international law on the freedom of a country to exercise jurisdiction within its territory with respect to conduct that is occurred in a foreign country. Having understood all different shades and colors of different principles in the light of three judgments, then we will try to examine at this juncture, dear learner and the viewer, that legality and the legitimacy of the extraterritorial application of competition law. The jurisdictional theories must reject tendency to present territorial sovereignty as a sort of jurisdictional artifacts or as a touchstone of an older and no longer terribly useful approach to resolve regulatory conflict. A cosmopolitan jurisdictional model would reject the construction of community as a geographically determined territory circumscribed by the fixed boundaries, instead bringing into a new and multiple interest and affiliation that defines our sense of community, thus dividing the world into compartments, as it has been aptly remarked by one noted scholar man, or to put it, no longer a satisfactory or even viable way of conceiving or regulating the global economy, then what we find that the power, treaty, and sovereignty ignores the diffusion of both the conduct that must be regulated and also the means by which regulatory authority is asserted in the global economy. The methodological dimension enunciates or the methodological framework of extraterritorial application envisages a basis of trans-governmental communities or in community values must integrate the relevant values that are sometimes expressed through invocation of territorialism. Now we are reaching to the conclusion of the lecture on the principles and theories of extraterritorial application of competition law by saying that there is a need to have a new approach to the extraterritorial application of the laws in general and competition law in particular, and this calls for transformation to a new approach which is very urgent and timely for any international or international business transactions. The countries should adopt a clear model for extraterritorial application of the competition law to protect their market while encouraging cooperation in the internal and the external sense of the economy. This alone will eliminate the extraterritorial application from any kind of a double dealing or a double standards or a double kind of a morality of the law or the competition law to the domestic and the foreign territories. Thus, the pertinent question that a country should consider when determining the extraterritorial jurisdiction of its competition law is to set a kind of a conduct first. Did the person or entity conducting the business transaction intend to violate an obligation set by the country of a foreign origin? Number two, how did and how will the transaction harm the country of forum? And number three, did the person or the entity engage in transaction pursuant to the direction or compulsion of the home country? All these inquiries necessarily leads to the fusion of the test which has been laid down in aluminum company case, in Lotus case, and the Barcelona traction case in an overarching framework of the law of extraterritoriality and competition. The analysis of the key attributes of extraterritorial application of competition law and the practical approaches contains a series of pertinent questions that a country should consider in the realm and regime of extraterritorial application of the competition law. The relative merits, demerits, and demerits of the effect doctrine under the Lotus and Barcelona traction cases and exceptions to the territorial principles, as has been discussed in detail, dear learner and viewers, under territorial principles, protective principles, universal jurisdiction principles, active personality principles, passive personality principles, and territorial effect doctrine should be dexterously examined so that we can reasonably sum up that in both situations, the extraterritorial jurisdiction or extraterritorial application of competition law does not violate norms of international law to protect a country's interest in a foreign country. And that ends the lecture of today's, which talks about, which try to encapsulate about the entire discourse, the entire polemics, the entire theories, the entire principles which are related under the international law as well as the comparative law and jurisprudence of the competition law in relation to extraterritorial application of competition law, or we can say the transnational competition law, comes to an end. And I hope that you will gain something in matters of your understanding about both the concept of the transnational competition law and extraterritorial and extraterritorial application of competition law, because that is something is cardinal to the course. Thank you very much. Have a happy learning.